You are wanted out of the state of Nevada, specifically Clark County, for a robbery. And you are asking me to set you a bond. Is this right? Okay. I don't know anything about you. I'm now getting to know you for the first time, so I don't know. My primary concern is, are you a dangerous person? Because, you know, I have so much drama in my life right now. It's ridiculous. I just don't need any more. And what I don't want to do is release you if you are a danger to my public, because I cherish that, right? I don't need any more. So we're going to find out a little bit about you, and then we'll see where we go from there. Amy, let's get to know Mr. Jefferson.
Yes, so he's wanted from Clark County, Nevada for conspiracy to commit robbery, and theft value over 100,000 or greater. The state's opposed to a bond at this time. He, as the court knows, he's being held. Well, he's not being held. He's made bond also on robbery threats in the 228th and reckless driving.
He has another robbery here?
Yes.
That's local?
Yes, it's a robbery threats in the 228th. It is open. He's made bond on that.
Okay.
So you got a robbery there. You pick up a robbery here too. It's a robbery.
This warrant was also issued December 18th, very recently.
When was bond posted, if you don't mind on that?
Yeah.
He's actually he's on bond. He's on bond for reckless driving.
Okay.
Picks up a robbery here in September. So I guess he's on bond for a robbery here, and now he's picked up another robbery in Nevada.
I thought the robberies in Nevada were old.
Well, she said they were just issued 12/18.
He made the bond for the robbery threats on September of this year. That case was filed also September of this year. And then this new warrant was issued this December. His reckless driving was...
What court is that out of?
That was the 28th.
No, the reckless driving.
Oh, this one's out of court 10.
What's the court date on that?
That is
January
on January 30th.
He has a general order bond on that.
Yeah, he's made bond on that one. He also has made bond on the robbery.
And he's made court, has he made, my question is, if he's made his court appearances, Your Honor, I mean, I think he's proven that he should go into court, showing up to court. So if you did consider bonds, he could then, don't worry about the reckless driving.
The state also wanted to add that he was just barely out of parole from earlier this year.
He was what?
Barely out of parole from earlier this year, as they have.
What was he on parole for?
That I don't know exactly.
Mr. Jefferson, I got to be frank. You scare me, man. You know, you continue to pick up cases, and they're serious cases, right? Second degree felony. I don't know, maybe this is a third degree, but nevertheless, you have a robbery here, you pick up a robbery over there. That scares me. If I let you out, are we going to get a third one? I don't want that to happen. I know you're telling me no, but history tells me otherwise. All the open cases tell me otherwise. Now, I do have some good news for you. The good news is that you've made bond on these two cases here, so there's no holding pattern, meaning that Nevada has 14 days to come get you, and if they don't come get you, then Harris County releases you. So you have that going for you now, you know, but I just don't feel comfortable giving you a bond. You scare me, man. The last thing I want is a third robbery. You understand? You got to understand from my perspective, I don't know you. You're telling me all these gumdrops and rainbows and bunnies jumping in the woods, but you've got all these 3 open cases. They're serious. Sorry, I can't, I mean, just.
Okay, he signed on Monday, Judge, so I guess,
so
can we reset it to what is that, the 8th?
Case, right, Monday, so 1, 2, 3 days have passed. So you got another, what, 12 days, give or take?
So can I get a reset for the 8th? Is that correct? If I'm counting it?
The 7th.
The 7th, even better. Okay.
Yeah, so you said the 23rd?
He signed on Monday, the 23rd, is my understanding. So I think the 7th.
Yes, the 7th.
So they're not going to get the 7th. He'll be released in Harris County.
So they have until the 6th to come get you, okay? If they don't come get you by the 6th, then on the 7th, you'll be released. But you got to understand, even if we release you, that warrant will eternally remain open. And you could get picked up again the minute you walk out of custody. If you do get out, I would immediately go back to Nevada, take care of that. Otherwise, at some point, you're just going to get picked up again, and it's going to continue to happen.
You can hire an attorney.
And the other thing is that, right, when you do go up there, you got to let your attorney here know what the plans are so that you don't get revoked upstairs here, because then you're going to be in the exact same situation over there like how you are here. You understand? So if you go over there to Nevada and try to handle things and they put you in custody and no one knows about it here in Harris County, you have not advised your lawyer, they may think that you've just jumped ship and they might revoke the bond here, and then they'll place a hold here in Harris County because you're in Nevada. And if nobody knows, you know what I mean? So you got to let your lawyer know here.
You're a misdemeanor lawyer on your record. Do you have a lawyer for both of them, or were you appointed lawyer?
Not a lawyer.
Okay, so you need to tell your lawyer that if they don't pick you, you need to contact him, let him know you're in custody. If he doesn't.
He has a lawyer in the felony, so
Yeah.
let your lawyer know in the felony
You let
case.
them know, and if they don't pick you up, you need to hire someone in Nevada, try to get you bonds on those, or you're gonna have to go out there and address them and turn yourself in and then see if they give you a bond.
All right.
So they don't revoke your bonds here, you're gonna let your attorney know. You understand all that? All right.
Okay, man. Good luck.
Thank you, Ron.
Thanks, Frank. Thanks, Amy.
I think that's all I have.
Good morning, Mr. Rodriguez. So you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and or a $4,000 fine.
Judge, on December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that he followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close, and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor, the sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, on December 18th, 2024, the officer was
So same day.
same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant, who stated that the defendant broke his window with a rock. The officer made contact with a witness who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house, and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200. Yes. Oh, okay. My apologies. I was reading because he was just picked up an assault. Let me read the assault that was the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. The officers detained the defendant, and a search of his person revealed 0.68 grams of meth in his right pocket, and the defendant was taken back to the original scene, and the officer spoke to the complainant, who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. A witness, the complainant's girlfriend, witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication.
Yes, Your Honor.
If you have a problem with drugs and alcohol, you better address it, because I'm telling you now,
No, it's not a problem, sir.
look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything.
I consume marijuana.
Stop. I'm sending you for a drug test now. I'm gonna have you come back. I want to see what's going on. That's it.
Okay. All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test and I want you to come back. I'm going to appoint your lawyer today. As far as your bond conditions are concerned, you're not to have any contact with the complaining witness in this case, not to go where they live, where they work, where they breathe. You're not to be in possession of any weapons. Do you understand? If you violate these conditions, you know what's going to happen. Do you understand? All right, please. Great. Come up, sir.
And we have those results.
Great.
Judge, for THC, MDMA,
So I don't have any of those.
Okay, so what I'm going to do is I can give you an application, but if you just put zeros, I'm going to send it right back to you. I need to know how much money you make, how much money you have in the bank, how many cars you have. If you own a house, I need to know the value of the house. Everything I need to know. Do you understand? Okay. Good morning, sir. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 18th, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas, and the officer met with the defendant and complainant, who are members of the same household. The officer observed no visible injuries, and the complainant stated she had been living with the defendant for 7 months. The complainant stated they were arguing in the morning, and the defendant pulled her by her legs off the couch. The complainant stated she hit her head on the coffee table as a result of the defendant pulling her off the couch, causing her to feel pain. The defendant stated the complainant had been evicted and he let her stay with him. And the defendant stated the complainant said something disrespectful, so he pulled her off the couch, but not hard enough to hurt her. The defendant said the complainant then started hitting him and he was blocking hits to defend himself.
Okay. Mr. Whittington, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with him or no?
A rip was attempted, but there is no contact yet with the complainant.
All right. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand?
Yes.
A protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can and probably will file additional cases against you, including a violation of protective order, which is one of the worst cases you can pick up. Just don't have any contact with her and everything will be fine. Do not pick up a new case. Do you understand?
I understand.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Ramona, sign a reset, and then after that, you're on your way. All right? Please, sir. Good morning.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On December 18th, officer was dispatched to a driver asleep behind the wheel at 1219 Shepherd Drive. Upon arrival, officer observed a red van with the ignition on and running in a parked position in the middle of the roadway, sitting in front of the railroad tracks. Officer woke up the defendant and observed slurred speech and red glassy eyes. Defendant stated he had left a Christmas party at Club K9 and had consumed multiple Michelob beers. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk concern, and 2 out of 4 one-leg stand. DIC was read, defendant consented to breath, 0.127 and 0.127, no criminal history.
Got it. Do you see if he has a valid Texas driver license? Do you
I
mind?
can run it now, Judge.
Please. Mr. Miller, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. Do you understand?
Yeah.
You have a lawyer. Because you have one, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel. If he comes back and tells me he can't get a hold of you because you're playing games, you're ducking and dodging phone calls, I will issue a warrant for your arrest.
And license is valid, Judge.
As long as you have a valid license and liability insurance in your name, you may continue to drive, but just be careful. If it does get suspended or if you don't have insurance, you're not allowed to drive.
Yes.
We good? Okay. Questions?
No questions, Your
All
Honor.
right. So I'm going to have you guys meet with the coordinator in court 6, and then you guys are good to go. Sir, you're charged with assault of a family member. Your case is 662 days old. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 5th, 2023, officer dispatched to a residence in Harris County, Texas, and met with the complainant, who said she had been dating the defendant for 4 years. Complainant stated the defendant had been drinking a lot and noticed his driving was unusual and told the defendant multiple times to switch so she could drive. The complainant and the defendant switched, and while she was driving, they got into a verbal argument, and the defendant hit the complainant on the right side of her face, causing pain. Once they arrived home, they got into another argument, and the defendant started throwing the complainant's clothing and belongings out of the window of their apartment. The witness was in the car with the complainant and saw the defendant hit the complainant on the back of the head, or on with the back of his left hand on the right side of her face 1 time.
Okay. I'd like to redo the protective order. Listen, one was already entered. Do we need them to do a new one? Mr. Harris, I'm entering in what's called a magistrate's order for emergency protection that identifies the complaining witness in this case. She is now a protected individual. You cannot communicate. You cannot do any family violence, assault, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Do you understand? If you violate this protective order, the state can and probably will file a violation of protective order, and it's one of the worst cases you can pick up. Before you leave, you need to get to know this protective order so you don't violate it. I am ordering you not to have any contact with this person and not to be in possession of weapons throughout the remainder of this case. Do you have a lawyer today? We're giving you one today to figure out what's going to happen with this case. Your case is 662 days old, and we set cases for trial at 180. So we're going to figure out what happens with this case. I'm going to have you, well, for now, we'll just have you take a seat in the jury box. If you can reach out to the MAC, please.
Yeah.
Good morning, sir. Sir, you were charged with driving while intoxicated, first offense. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 18th, 2024, the officer was dispatched to 3800 Southwest Freeway in Harris County, Texas, in regards to the defendant's motor vehicle hitting another motor vehicle and keep going. The caller stated the defendant's motor vehicle's tire fell off and that the motor vehicle was at a strip center parking lot. The officer observed the defendant's motor vehicle facing the Southwest Freeway frontage road and partially on the curb, leaned against the hedge. The officer observed the engine running.
This is the exact moment where the legal discussion shifts toward risk assessment and judicial discretion. Legally, when a court considers bond decisions, one of the biggest concerns is balancing a defendant's ability to remain out of custody against the safety of the community and the likelihood of future compliance. Emotionally, you can hear the concern building because Judge David isn't reacting to a single allegation. He's looking at multiple open matters unfolding at the same time. Here's the question. If someone already has several active cases and new allegations continue appearing, at what point does the court become too concerned to take another chance? That line can be difficult to draw because every decision carries consequences on both sides. And with Judge David now weighing public safety concerns heavily, the courtroom moves into a critical stage of the hearing.
Officer observed the engine running, the defendant's vehicle in drive, and the left front tire shredded. The officer further observed the defendant sleeping, slumped over the steering wheel, and a strong odor of an alcoholic beverage, bloodshot eyes, slurred speech, and the defendant, upon waking, had poor balance requiring the officer's assistance. The defendant stated he consumed 2 mimosa beverages and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were .169 and .162.
Got it. Any prior DWIs and
No, Your Honor.
license?
Oh,
Okay. I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, I'll put you in jail and I'm going to revoke your bond. Do you understand? What do you do for a living, sir?
I currently don't work. I got assaulted recently. I lost my job.
Where were you working? What were you doing?
I was a Uber and I worked at a restaurant.
Why stop? You still need money. How are you getting money?
I had to do light recovery.
Okay. Did you want to apply for an appointed lawyer, sir? You're going to go hire a lawyer.
I can't afford one. I need a,
That's what I'm asking you. Did you want to apply for an appointed lawyer?
but I will. No, I'm not.
Do you want to?
Yeah.
Okay. Do you mind? I'm going to give you an application. I need you to fill it out. I need you to fill it out in its entirety. I need everything. I need to know everything about you. I'll take a look. If you qualify, I'll provide you with a lawyer today. Does he have you said he has a Texas driver license,
I
right?
see an eligible license driver.
You don't have liability insurance, then you're not allowed to drive. That's car insurance. If you don't have it, don't drive. I'm making that a condition of your bond. You must have a valid Texas driver license and liability insurance in your name. Do you understand? Okay, I'll have you fill out the application, Stephen. I'll have you sign a reset, and then we'll have you take your seat in the jury box. No alcohol, no dope. After you're done with that, you'll meet with pretrial services, so they'll go over your bond conditions. All right? Good morning. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, yes. On December 16th, 2024, at approximately 12:48 a.m., officers were dispatched to a major crash at the 6100 block of Richmond Street in Harris County, Texas. Upon arrival, the officer made contact with the other officers who had advised that when they arrived on the scene, the defendant, the sole occupant of the motor vehicle, had crashed into the ditch. Upon contact with the defendant, the officer observed bloodshot, watery eyes, slurred speech, and a strong odor of an alcoholic beverage. An inventory search of the vehicle revealed one bottle of whiskey under the front passenger seat, which was 2/3 empty. Standard field sobriety tests were attempted. HGN 6 out of 6. The walk and turn was refused, and 4 out of 4 on the one-leg stand. The DIC was read, but the defendant refused. A blood search warrant was signed and executed.
Can you run his criminal history, please? I'd like to see if he has any other DWIs.
Your Honor, there's no prior DWIs.
Is there an allegation that he was allegedly consuming alcohol while he's driving?
No, Your Honor, they only found a bottle under the passenger seat, not cold with touch or anything like that.
Mr. Nesbitt, I'm going to find that there's probable cause to go forward with your case. Have you run his license to see if he has a Texas driver license?
It's eligible, Your Honor.
All right. I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand, sir?
Yes.
Okay. You have a license. You're not allowed to drive unless you have car insurance as well in your name. I'm making that also a condition of your bond. Do you understand?
Yes.
Do you have the ability to hire a lawyer, sir?
I'm sorry.
Are you working? What do you do in life?
I'm a mechanic.
Okay, money.
afford an attorney.
Do you want to apply for an appointed lawyer, sir?
Yes.
Okay. We'll give you an application. I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. I need to know everything about you. And if you qualify, we'll appoint your lawyer. But just remember, don't consume alcohol. Don't use illegal drugs. You understand, sir?
Yes.
Okay. Stephen will give you the application. I'll have you sign a reset with Ramona, and then we'll have you take your seat in the jury box, sir. Did you want to talk?
Yeah, Judge, I've got a case, Derek Adams, on the docket. He was supposed to complete 2 classes by today.
Not do it?
No, he did,
Right.
but he didn't pass one of them. And the contract doesn't require passing, it just requires taking. And so, Miss Saba, hey,
Judge,
we have the contracts.
I just needed chief approval that that's sufficient. I've never been in this situation. Like, I don't know if I can dismiss a case for failing an effective decision-making
Okay.
course, but
How do you
attempting
Get
it.
this, Judge, there's not a single chief working today. So it seems like there's not really effective.
So let's roll it to tomorrow. Have him take it again.
I'm not coming back here.
Zoom in. That's why I have Zoom, to make it easier for you.
That's true. I'm appointed. Money's really tight for him. The
The case
contract,
is 1,292 days old. We've given him how much grace to get this thing done over and over?
And
Really?
it was
Judge.
just 2 classes,
I know.
Judge.
Last time, if You didn't have it done. You didn't have it passed. I'm carrying you day for day.
The contract doesn't require passing. I mean, I'm actually serious about that. Although it's funny.
I would be hard pressed to find a chief that's going to acquiesce to that. I mean, really, I don't know.
It was it was a pretty good PTI offer, Judge. It was just effective decision-making and a gun safety class, both of which are 2 hours. The effective.
Yeah, it's a 2-hour class, right?
Costs $22, I believe. There's no reason he shouldn't be able to do it again.
Just, a lot of times they don't take it seriously. So let's roll it to tomorrow, have him do it again, and then let him know we're going to redo it day for day until he gets it done. At nearly 1,300 days, I have no sympathy for this person.
What's the term? A collateral estoppel or something like breach of contract? It's not my bag of chips.
Remember, they're the ones that have the power to dismiss. I don't.
Right.
They're the ones, I just sign it. They're the ones who actually file the motion.
I know that.
So do we know when is she coming back?
I mean, Kelsey won't be back till Monday, Judge.
Okay, so let's roll it to tomorrow.
Yeah.
Have him take it again. Maybe he'll pass it this time. Tell him to pay closer attention. It's only 2 hours. It's not much. If he doesn't want to do it, okay, I'm just going to roll him to Monday. I'm going to keep doing it. It's 1,300 days. We got to take care of this.
As long as I have a chief tell me that the attempt is fine, like I just can't make that call, Judge.
Did you see how good of an attempt it was?
He failed it. It was like a 50%.
Somewhere around 57.
So
I'm rolling it to tomorrow.
is there a possibility that we're gonna have a chief?
No.
As long as there's another
one
chief.
But if he passes, it gets dismissed.
Yeah. And I can ask another, if our bureau chief is here or one of our deputy dogs, I can go ask them after docket, Judge.
It's up to you.
Oh, I've been around everywhere. There's no chiefs.
Well, I mean, they would be on the 5th floor, Judge.
Yeah. Well, regardless, I mean, we have a lot of work to do. We have 3 other courts that we need to cover as well.
Yeah.
So have him try it again tomorrow. If he doesn't want to do it, then we're just going to roll till Monday. Yeah, really.
Is Glenn here?
He's here, yes.
Adams?
Come on up.
How you doing?
Hi, Joe.
Hi, Judge. Nice to see you.
Merry Christmas, sir.
Merry Christmas to you, Your Honor.
What are you doing with your client?
Yes, sir. I did talk to him about the most recent offer that came in this morning. And the VA's not here, so I can't really respond back to her on some evidence. So we were going to go on.
Judge, she emailed me this morning. She's looked at the mitigation packet that defense sent, and she emailed me this morning telling me what her offer is. So everything that I relayed to her is her latest update.
What is the offer?
It's a 9-month deferred, Judge.
Yeah, and Your Honor, one of the things is just from reviewing this, it doesn't appear that the mitigation made it clear enough, or they didn't take very seriously the statement that the house that the complainant and her mother's living in right now is owned by my client. He's the owner of that house. And they are living there because he's allowing them to live there. Now, he's charged them rent before, but he has not moved to evict them. He wants this process to end. But somehow from the notes that they were reading.
What's your client's name? What is your?
Hudlow. Hudlow, HDLO.
Yeah.
And
the problem is that it's really old.
Your Honor, and I discussed that with them, and so they're willing to keep. He wanted to talk to Mr. Garza directly. I've been back there calling for the last 30 minutes, if not longer, trying to reach him.
What we can do is I can give you till Monday, but it's plea or trial on that day.
Yes, sir.
Mr. Hudlow, come up.
And Judge, the state's offer is going to stand. I mean,
Come around this way, sir. All right. Good morning, Mr. Hudlow.
Morning. Merry Christmas.
You got to understand reasonable minds can differ. Just because you want something a certain way doesn't mean that it's going to happen. In life, it goes like that in every aspect. When you're buying a car, when you're buying a house, whatever it may be. He can't control the offers as they're going to give. He can only tell them merely what, he is given a certain set of facts and he has to work with those facts. Sometimes they're good facts. Sometimes they're not so very good, but it is what it is. Now, our case is old. It's 210 days old, and we set cases for trial at 180 days. And I have no idea how this got to be as old as it is now, but it's time to make a decision. Now, your case, they have offered you a 9-month deferred, which is a type of probation that if you successfully complete, you do not end up with a conviction on your record. You can't tell people it was dismissed because it's not dismissed. It's merely a probation that you took. If you complete successfully, you don't end up with a conviction, right? But that's the offer that they've made for you, and it appears as what the state has said, that it's going to stand. Look,
Happy with that, Your Honor. Oh, I'm sorry.
you don't have to make a decision today. If you want to make a decision today and you want to be done with it today, we can do that. But I can give you one final setting to Monday if there's other people that you want to talk to. It's up to you, but it's time to put this baby to bed once and for all. So I will give you the opportunity now to talk to Joe to see if that's something that you want to accept now. If you need a little bit more time, I can give you until Monday. But at that point, you must either accept the plea bargain or agreement, or I'm going to set your case for trial because it's just too old.
I haven't had a chance to talk to Eric. Can we set it for Monday?
Okay.
I'm not saying that,
No, look,
Actually, I would go
you
with-
don't have to say anything. I'm happy to do that, but you get no more resets after that day. So if you're unable to get a hold of him or whatnot, I don't care. You need to be diligent in getting together with Eric to figure out what you guys want to do with the game plan. Take a look at all the evidence, and then you make an informed decision at that point. But there's just no more time after that. All right?
Yes, sir. Yes, sir.
And I'm sure that Joe can try to get you, help you get with Mr. Garza, okay?
I don't know with his vacation schedule, I don't want to put anybody out, but that's kind of how I think we ended up here.
We have too much.
Thank you, sir.
All right, guys. Good luck.
Thank you,
Joe.
very much.
Today's hearing covered much more than isolated criminal allegations. Throughout these proceedings, Judge David repeatedly focused on accountability, compliance with court conditions, and the responsibility that comes with receiving opportunities from the justice system. Whether discussing bond conditions, protective orders, substance restrictions, or long-delayed cases approaching trial deadlines, one message stayed consistent. Decisions made outside the courtroom can eventually shape what happens inside it. The hearing also highlighted how judges often have to balance public safety concerns with giving defendants a chance to move forward responsibly. Cases like these carry real consequences because every ruling can impact future opportunities and legal outcomes. If you found this case as intense as we did, hit that like button, share your thought in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.